Hi guys, it's Kathy. I hope you're doing well. I need to get into the Hurd case because it was very uncomfortable last night at work. Very uncomfortable. There's this guy who's been coming in. We've been open for a little over 4 years now, and he works at a carpet company pretty close. Like a couple blocks down the street. And him and a lady coworker have been coming in since we opened. They're older folks. They're older than me, and they come in. I know what drinks they want. I know what they need for Christmas for because they buy each other Christmas gifts. I know what they need from me for Christmas. So I get into work tonight, and the guy is there with this other woman. And I walk up to the table. You know, Hi, how are ya? Because I know him. I'm like, hey, how's it going? And before he even gets a chance to speak a word, she starts speaking to me. And she's like, hi, my name is Lauren, or whatever, Lauren. I'm his wife. You probably didn't know he had a wife. That lady he comes here with for the last 37 years, she's his whore. I'm his wife. Oh my God. And they stayed there for hours. So apparently she just found out he's been having an affair, and she wanted to go to where he goes to with this other woman and, make it publicly known, because she said that to every single server that and other people that were just walking around. there was They sat there for hours. So we have this real long bar, okay, and there's two sides to get out. You can get out on the right or the left, and most of the dining room is over to the right, all right, and then there's left side. So if you want to get to most of the dining room, you leave the right side. Right there is table 10. Every time I went out, every time I had to go out into the dining room, which is about a billion times a night, she's there yelling at him, or like giving me this weird, I don't even, it wasn't a smirk and it wasn't a scowl, just this. I mean, I understand where she's coming from. I understand what's going through her head right now. I understand her rage and hurt. So, he had to sit there and listen to it for hours, um, which really, I don't really feel bad for him. What did I do? I kept giving him beers. I know what he wants. I made sure his beer was full. I didn't get her a refill once, though, because she made herself unapproachable by a server, by the venom and the poison coming out of her, which I understand. I was not able to ask her if she wanted another drink. I didn't even ask him if he wanted another drink. As soon as his glass was empty, I had one there. Oh, I really like I really like his girlfriend too. I mean, she's a great lady. She's very classy. She's super tall, blonde, clothes horse. He's super tall, blonde, and they're older. But oh yeah, he definitely paid the bill. He's gonna be paying that bill for for a while. I don't know. You know, it was an awkward night. Awkward, awkward, awkward. And there I am with the band singing and clapping and yelling. those guys, those guys are there fighting. It's a bar. That's what happens at bars. All right, it's time. I couldn't wait to get back to this case. It's so good. So I think, oh gosh, I think we're in April of 22. Then we go to May of 22, and then we'll start August of 22 today. I believe Pennsylvania has alimony. You want to know why? I believe while I was getting my divorce, I would have had to pay, which is crazy because I had the kids. I mean, I had the bills. Everything is in my name. I always made more than him. He didn't work a lot. He worked whenever he wanted to work, and then he didn't work. So I had to take care of everything. And then when we got divorced, it got close. I almost had to pay him alimony and take care of the three kids. Um, and he didn't pay child support right away. They didn't make him pay anything. So I would have had to take care of everything, and so I really think it does. Yeah, I'm not paying. I'm not paying you alimony. I'm not. I will go to jail before I pay alimony. I will. I'll sit in jail. I don't mind sitting in jail. They have tablets in there. Did you know that? I know because well, never mind. Never mind. So I'm a little nervous about this first clip. Um, it's April of 22. I don't think we saw this one yet. So today I plan on doing April, May, and the first half of August, unless we already saw April, which I hope we didn't, because that would mess up the whole time. I have it cut into exactly 2 hours. But you guys will tell me real quick if we already saw this. I know it. This trial is really good. Oh, not trial. All of this stuff is really good. I'm really enjoying it.
Okay.
We are on the record.
Very, very good. We're on the record of Papari versus Hurd, D622669. Ms. Hurd is here in a respondent's table and representing yourself, I believe?
Yes.
Okay. And Ms. Chrome is with Mario on the record. We apologize for the delay. We're really behind our time. Looking at the temporary...
Damn, guess what? We saw this. That means, so here's a problem with that. That means we go to May, which is 17 minutes long. And then August is 2 clips of 1 hour. So we can either do 1 hour and 16 minutes today, which is probably what we're going to do, or 2 hours and 16 minutes today, which is probably not what we're going to do, because I have a double. I have to work a double, so I can't add on. Well, I'm not doing OJ. Fine. We're going to go to May, and then we're going to do both of August. Screw it. We're just going to do it.
Okay, Your Honor, we're on the record.
We're calling the case number D-21-622669-C, Opipari versus Hurd. Please make your appearance for the record. Counsel, please state your bar number.
Good afternoon, Your Honor. Shaka Chrome on behalf of Mario Papari, bar number 8116.
Ms. Hurd?
Kimberly Hurd, self-representing.
All right. Looks like we have 2 motions here. First is the motion to strike. This is a motion to strike the defendant's answer and counterclaim and to disallow the defendant from calling any witness or using any exhibits for trial and for contempt and related relief. I have bad news for you, counsel. I don't have the power to grant any of that. All that power rests with the district court. So I'm happy to hear your argument on the matter, but I'm inclined to suggest that I would deny the motion without prejudice and allow you to file it in front of the district court because the district court's the only one who has that power.
We discussed it at the last hearing, so it's just for the protective order that we're here. But thank you.
Okay. All right. So I will, for the record, deny that motion without prejudice. Now, the second motion is protective order regarding the subpoena that was sent to the city of Henderson regarding
Yes.
the plaintiff's employment records from back in 2017. And Ms. Hurd, I'm when it's your turn, I'm anxious to hear what claim this relates to. I pulled up the counterclaim in this matter, and the counterclaim in the counterclaim, you suggest that both you and the plaintiff are fit to be custodial parents. And so I need to understand the information that you're seeking, what it relates to. I know in your pleadings that you're suggesting that it relates to fear that you have that your child will be abused by the plaintiff in some way. I don't know that you've made the nexus between that fear and the documents that you hope to get from the city of Henderson. So I would like you to address that when it's your turn. Ms. Crum, this is your motion. Please go ahead.
Thank you, Your Honor. Just so you're aware, I think we're up to 19 pages of a docket in this case. Ms. Hurd has sent messages on Facebook that are disparaging to my client. She's stalked him. The police has actually advised my client that if she continues, he should file a TPO. He put recording devices and trackers on his cars. She's jogged by his house, and a few weeks ago, she sat in front of the house and the police had to ask her to move. We have grave concerns that if she were to receive any information, that she would use it not for this case, but for any other purpose. But it's not even germane to what we are trying to resolve in this case. Right now, my client has sole legal, sole physical custody pending trial. The judge has advised her what she can do to work on herself so that she could, obtain some more custodial rights. She's not doing those. She has not made any initial disclosures, and we believe she should receive sanctions pursuant to Rule 37. There's a report and recommendation that became an order where we were granted a motion to compel her discovery responses. She still hasn't responded to those. In January this year, she filed a motion saying that they should have joint physical custody with my client having half the week. And when he didn't agree, then now she's brought forward this claim. And in January, she specifically said, I do not believe that he will sexually assault this child. So now to bring up this claim after failing to participate in any sort of discovery, after losing custodial rights for this child, it's just grasping at straws and, and not giving us any documentation to be able to use in trial at the same time. And even on her items to be produced, he asked for settlement offers and confidential information regarding the resignation. The resignation was in 2017. They did not separate until 2020. And she's had plenty of time, if she was really concerned that there was some problems with him being a father to this child, that she could have brought an emergency motion before the court. Instead, what she filed was, I think we should have joint legal, joint physical custody. So I would ask that our motion be granted and that I be able to submit a memo for fees and costs. Thank you.
Ms. Hurd? Thank you. Ms. Hurd?
Hi, do I need to address everything even if it's not relevant? Because we're here for a protection order. And the thing is that yes, he was terminated in 2017. He told me that he was terminated for officer safety. I have discovered that it's very possible that he was terminated for sexual harassment. He does have a handful of sexual assault allegations, one of them being done by my 19-year-old niece when she was living with us, and this was during that time frame. I didn't know this. This is stuff that I'm learning as I'm going through this process. You never told me the truth, and I'm hoping that I'm wrong. It says right here, she just put another production. She's asked me 4 times to produce evidence and claims, documentation, evidence in my claim that Mario sexually assaulted women. Well, that's what I'm trying to do. If he was terminated for officer safety, then it doesn't apply, and we don't go anywhere, and it doesn't mean anything. But if in fact he was terminated for sexual harassment, that very much validates a lot of the claims that these other women are making, because they're in the same time frame, and also that I think that's very relevant with the special needs child custody case. Now, this wasn't. I did have an attorney during that counterclaim.
I just failed to find her on Facebook, so if anybody else can find her, let me know.
If I have to refile based on some of this, I'm learning. I'm learning the process here. I'm trying to do my best. My daughter was taken away. I feel it was unlawfully. That's not relevant to what we're talking about today. We can discuss, so I'm trying to teach myself. I'm going to classes. I'm trying to educate myself. I'm going to the law library, and I can't keep up. I've asked Ms. Chrome if she could provide these in Word formats, because I know I have to type everything up. I don't have an application to be able to type it up and answer it. I actually have handwritten notes on every single one of them. She never provided that. I'm trying to work with her. I don't get any response. So I've made offers with no response, no counterclaims. I don't want to be in court. I'm trying to settle this fair, but also, again, with these allegations, I don't want them to be true. I'm hoping I am wrong, but this is one of the most credible sources and ways that I can try to back up my claims. And again, if I'm wrong, I'll be happy, and we don't need those documents. But this is the only way, and I didn't learn of this until after we were separated.
Tell me about the form in which you have claimed to the court that the plaintiff has sexually harassed women. Is that an emotion of some sort?
So I sent a subpoena to the city of Henderson.
I understand that.
Okay.
I understand that.
So what form?
Have you filed a motion? Is there a motion before the court with regard to custodial parent issues?
Yeah, we are in pretty heated, high conflict type custody right now. We have an evidentiary hearing in August.
And the evidentiary hearing is to determine permanent placement of the child in custody?
Yeah, in custody. And again, like I said, this is relevant because this also, there's other women that have come forward. I'm hoping to not have to disclose their names. I'm hoping not to have to disclose any of this because this is not fair for me.
You haven't disclosed their names to Ms. Chrome?
That's part of the witnesses. So again, I just did a litigation class, and I submitted that back in end of April. So I'm trying to teach myself what I need to do, and I've gotten the correct forms, and I'm attempting
But she didn't answer the question. Did she submit the names to Miss Crow?
to get all this that she needs, everything that she's requesting. I'm a little overwhelmed, but I'm trying.
Okay, Ms. Chrome?
Thank you, Your Honor. As she said, we're trying to prepare for trial in August. This case is over a year old. She didn't bring these allegations for the past year. I don't have any witnesses. The only thing that she did provided in her opposition to this court is text messages from 2017. So again, if she thought in 2017 or even when this case originated that there was an issue, we would have brought this before the court in front of Judge Henderson. But now it's not until after, my client gets emergency sole legal, sole physical custody, after her drug test results are bad, that she's searching for anything to try and get an equal standing or something. But it's unfair to my client that, again, we don't even have initial disclosures. We don't have any witnesses. We don't have anything. And so to make these claims and then also to harass him on Facebook and coming by his house and recording him, who knows? She's admitted that she's on medication for some, depression, some other issues. I don't know what she would do with this information, and I don't think it's relevant at this point because she's waited a year to try and seek it. And for her to say she doesn't know how to provide discovery to me, she has filed so many motions because it doesn't cost her anything. She has overwhelmed my office and the court with repetitive pleadings, yet she doesn't respond to even providing us with a witness list. So I'm just asking for it to be denied, for us to receive fees, so that maybe she'll take it serious if she has to actually pay something, to keep up making these false claims over and over again, now that she's been found to be an improper parent temporarily until we go to trial.
That's not true. That was never founded.
Okay, speak to me, not to counsel,
Your Honor,
please.
that she's making, right now, she's fabricating a lot. I've never been shown to be unfit. As far as I put stuff on Facebook and go by their house, there's no proof of that. She's making a lot of allegations that are hearsay and have no substantial evidence to back them up. She just comes off the top
Objection,
of her head,
hearsay.
whatever she can, to try to make me look bad. I do take this seriously. Right now, I'm fighting for the safety of my daughter.
I have to know if she has a dog, and I have to know if it stepped on a bee.
I feel that she is in a toxic environment. This is one avenue that I have to prove. I had an attorney a year ago. I did address this with him. And in fact, I have letters. I submitted them. They should be in the pleadings that you have, that I submitted as a response. Letters to and emails from my attorney to her with these allegations and this concern. Why my attorney did not put in
Absolutely.
a counterclaim, we were really hoping to not have to go there. But this has been something that's been of concern. It's been in correspondence between me and my attorney Jason Stoffel and Shaka back a year ago, last summer. So yeah, for her to say that, that's not true either. And I would request that these allegations that she's making as far as coming up with, that they stop. Unless she has something to actually prove substantial evidence, just making these allegations, and I drive by their house, that I make posts on Facebook. I haven't been on Facebook in probably about 9 months. And that one exhibit that she did submit, doesn't even have my name on it. It's a supposed Facebook post that I made, but my name's not on it, and it's not date stamped. So, again, she just likes to make a lot of allegations. There's only one way to support any of these claims, and that's to get this subpoena from City of Henderson. If I'm wrong, then I have no means. If he really was terminated for officer safety, then this doesn't go anywhere. No, I can't use that. It's not related to this case, and it won't mean anything. But however, he was terminated for sexual harassment. That is very much relevant to a lot of factors in this custody case, especially a little girl that's going to be 6 tomorrow, has Down syndrome, is still in diapers, and does not have expressive verbal communication.
All right, I'm going to recommend that the motion is granted. Ms. Hurd, you've not provided me with any evidence that suggests that the plaintiff is even the subject of a sexual harassment complaint. You've indicated that you hope not to identify witnesses, but that's exactly what your obligation is under the rules. And you had that obligation to disclose those witnesses well over a year ago when you first filed this action. And I have to say that had you provided the court with information from these witnesses, I might be inclined to agree with you here
There is something
that,
by me.
hold on, please don't interrupt. I might be inclined to agree with you that you get to peek behind the curtain a little bit with regard to these particular allegations and to determine whether, and to test the veracity of the plaintiff, that he was terminated for safety issues and not for being someone who sexually harassed someone at work. But I can't do that where you haven't made the disclosures and you provided me with no evidentiary support for your allegation. I mean, to be clear, I wouldn't allow the subpoena to go forward. I would allow the plaintiff to obtain those documents, and I would do an in-camera review. And then if it was appropriate, I would have a protective order for the use of those documents because that is highly personal information. But you've simply given me no avenue to assist you in that because of your refusal to participate in discovery. So I am going to recommend that the motion is granted. Ms. Chrome, I'm going to ask you to prepare the report and recommendation. I want you to share that with Ms. Hurd. I assume you have a working email that you've given to Ms. Chrome?
Yes.
Okay. And you'll have 48 hours to review that and approve its form and content or not. And if you fail to avail yourself of that opportunity, Ms. Chrome will send that proposed order into the court without your signature and without your review. Do you understand that, ma'am?
Yes.
All right, very well. Ms. Chrome, you'll have until June 1st to return that report and recommendation to the court. We will set a hearing for 1:30 on June 8th to determine if that's been accomplished. If it has, there will be no need to appear. and the matter will be taken off calendar. All right? I wish you both well. Have a good day.
Thank you.
Thank you.
Very good.
Okay. That was May. Now we're going to jump ahead to August. This is 2 parts, so this is part 1.
Mario Apapari matter versus Kimberly Hurd, D622669. Plaintiff is present in court with Ms. Crum, and going to attempt to contact the respondent, who has not made an appearance, nor did she contact Chambers about any difficulty in appearing, but did file a last-minute motion to continue proceedings. Okay, well.
Can we all just be so happy he has a lamb today? Thank you for putting a lamb up there, sir. You're so nice to me.
Close it down. It's not going to answer. No response.
Speaking of no response, how's Kelly? Anybody? Anybody know how Kelly is? Where's Kelly?
Okay. A few preliminary matters. Defendant is not present. We went above and beyond and contacted the defendant, and no response. And defendant has filed a last-minute, without proper notice, request motion to continue, and the court will say it's based on the faulty premise that no deadlines were set or no case conference or 16.1 was attempted. But in point of fact, there's a Rule 16 proceedings occurred on February 15th, 2022, and there's an order to that effect setting the trial dates, all the deadlines, etc. And the court further notes that's an erroneous representation, and as well as an unfounded attempt at a continuance, since it was never explained what it is that defendant needs additional time to prepare for, etc. And defendant is also, we're also in a position that even if defendant were present, there would be no sensible reason to continue the matter, as plaintiff is incurring no doubt thousands in fees and has prepared all these voluminous books and prepared for today's trial, etc. So there would be no need to entertain a continuance unless there was something really major that a continuance would flush out, and that it would be highly prejudicial if it was not granted. No such undertaking has been alleged, just the argument basically that there's no Rule 16 compliance, which is false. Also, defendant rather has filed more than one appeal, apparently not understanding that these were temporary orders, and so those appeals were summarily dismissed. I also...
Guys. She's not here. This is 2 hours. This is a 2-hour hearing. This is part 1 and part 2. And she's not even here.
Understand that defendant may, not just by not appearing today, in conjunction with apparently no longer appearing for supervised visitation and no longer complying for drug testing, may have abandoned her desire to participate in this litigation.
Oh,
Now,
no,
that being
Judge.
said, the court does not want to create a questionable or incomplete or vulnerable record whereby the results of today's hearing are just based on a default type of analysis by her not appearing or participating, which would leave the record vulnerable to be reopened and or challenged on those grounds. So I think it would also be necessary that to the best extent possible, we establish that any rulings today are likewise established on the merits, not just the temporary order of sole custody in conjunction with the father, but then the determination of compliance or any progress by the mother since then, with attention to be focused on ATI results, of which we have several, plus, more to the point, the mother not cooperating with the latest ATI test or test, plus apparently not appearing for at least the last supervised visitation or two without contacting family first, which presumably is likewise interpreted as an intent or not to participate any further in the custodial litigation. Okay, Ms. Crum, you can remain seated, please.
Thank you. If I may just make a record about her motion really quick, Your Honor, just so you know
Sure.
some facts. I received notice that she filed, so we just reviewed it a few minutes ago. In her pleading, she makes reference to that she didn't have the opportunity to look at the Family First report. However, she had her mother come by my office to pick up my trial exhibits, which there's a copy of the report in there, so she has access to the report. Also, when she was taking drug tests, except for the last one, she would come to the court to view her drug test results. She could have done the same thing with the Family First. She has emailed your staff before, and she has the ability to do the same with the Family First. I tried calling her yesterday several times and sent her course.
Nope, I had to pause her because apparently she's just not allowed to talk this much. She has not been allowed to say this many words the whole time. So I had to stop her. I think it's the rule, right?
Correspondence because I had not heard from her and wanted to see if we could stipulate 2 exhibits. She never.
I don't know about that. Listen, the mom is so bad that we're missing how bad the dad is. I don't think this dad is a saint at all.
Returned the phone call. She filed a small claims case against the plaintiff. They actually appeared via Blue Jean this morning. The defendant was present via Blue Jean, and the judge that overheard that matter said, "Don't you guys have court this afternoon?" And plaintiff said yes at 1:30. So she was well aware that we were due here in court today, and she knows how to use Blue Jeans because she used it this morning and is not online with Blue Jeans right now. And I just wanted to make a record that it seems like she's arguing that we should have had a trial sooner than now, but this court has been so gracious with her drug test results and has encouraged her to get herself together so she'd be in a better position to ask this court for joint physical custody and joint legal custody. And so she's had plenty of time to do those things, and yet didn't appear for her last drug
He's
test.
been here every time.
So with that, I just wanted to state that there's several inaccuracies. I think this court has been more than fair and lenient with her, and hoping that she would get some help for her addiction. So.
Okay, we'll add those matters to the findings, not just as the last minute, egregiously untimely motion, largely based on a false representation of Rule 16 non-compliance. But it's also represented that she was oblivious to the Family First report, and it's been represented that she picked that up from Ms. Crum. It's also represented that she has ceased to appear for her ATI testing as well as the supervised visitation. And it's also represented that she can't validly claim that she was unaware of today's trial, as she was provided the notice at the last hearing. I believe this motion to continue references today's trial date and time, and Ms. Crum also represented the parties were engaged in a justice court small claims action earlier today, where the judge or hearing master inquired of her if she was aware that she had a trial today, and she said yes, custody trial at 1:30, so that'll all be entered into the record as well. Very good.
Actually, it was the plaintiff that said yes at 1:30.
Oh,
So
he
no
reiterated
further.
it to her, and she heard it, right, and
Yes, she
acknowledged
heard
it? Okay,
And then, Your Honor, too, she did not file a pretrial memo.
that's true as
She
well.
did
That'll be
not-
entered into the minutes too.
She never submitted initial disclosures, any disclosures in this case. She failed to provide discovery responses to interrogatories in a first and second set to request for production of documents. A motion to compel was filed where she was supposed to respond within 7 days of the order being entered, and she never responded, which all caused my client to incur.
It appears to be, unfortunately, a misguided situation. It's one of those situations which once in a while, not too often, but unfortunately sometimes occurs with a pro per, and it happened here, where it's clear she's decided not to comply with the court hearings and filing requirements, and instead thinks that she knows better, and that her challenging, her not appearing for court hearings and not making requisite filings, but to instead challenge this court with motions she doesn't appear at in Supreme Court appeals, that she perceives that's the way to go to protect her rights, and that she's otherwise not going to comply with the rules of appearing in court and filing the required paperwork. And it's really unfortunate. I hope she's not relying on advice from somebody or out there, some self-styled paralegal or something.
She is absolutely not relying on anybody else's advice. This we can be sure of.
Really misguided.
Unless it's like tarot cards. Maybe.
I hope she's just doing this all on her own, but based on the nature of some of these filings, I suspect she's receiving some help and probably some advice as well. And if so, it's absolutely atrocious, not just counterproductive advice, but very damaging advice to her. At least it's the way it looks. So I guess we're here for our final custodial determination
Yes.
with references, whether you want to simply make the representations or you wish
Yes.
to examine your client, but I guess we do have to walk through
Yes.
the
Here, I have one
A,
more
wishes of
procedural
child of
issue.
sufficient age, which is not the case. B, nomination of a guardian, which are not really applicable. C, which will more encourage frequent association. C, D, and O all interconnected kind of. D, level of conflict. E, ability to cooperate. Then, of course, F, mental and physical health of the parents. G, physical, and we can go through them one at a time
Sure.
if you prefer. Let's start with either through your testimony,
Yes.
him, and/or just your representations based on the totality of the evidence, because otherwise I kind of suspect what's coming here is that this was unfair, it was resolved on a default type analysis, even though she put herself in that position, but I want it to be fleshed out well beyond a default analysis, where we
Sure.
can rely on the significant record, not the least of which noncompliance with drug testing, supervised visits, et cetera, and so
Okay.
the A, wishes of a child of sufficient age and discretion. You would acknowledge that's not a factor in this case, right?
That's correct.
B, and guardian nomination, B, any nomination of guardian for the child by a parent is not, also likewise not a relevant factor,
Right.
correct? Okay, C, D, and E, and there's all bleed over between these factors. C is about who encourages a relationship with the other parent. D,
Sure.
conflict. E, cooperation. So starting with C, to the extent we're able to gauge that or have a track record of it, when they've kind of been under some pretty firm orders, and with supervised visitation, there's really not much room per se to weigh whether one parent rather than the other would encourage frequent associations beyond the court order, because we're on a very restricted supervised court order. So I'm not sure.
We have
Do you have
testimony on
anything
that.
to mention about that factor? Or-
We do. Can I get him sworn in and
Yeah,
then
yeah,
I'll ask him
sure.
some questions about it?
Will you please stand up and raise your right hand? You do solemnly affirm the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you.
And before I start, Judge, just one more procedural issue.
Okay.
Our Exhibit 4 was a stipulated behavior order that was signed by myself and by the defendant, but I
Okay.
can't find it entered. If we can have it entered into the court.
Was that ever in? Was it
I'm guessing she comes in late because this is 2 hours long. Should I peek or should I? Nope, nope. I'm just gonna let it go.
ever entered or?
No,
We
I
don't know
couldn't
if it-
find it.
Okay.
Okay.
When was
thank
it
you.
submitted? Was it submitted as an exhibit or actually submitted to the court
It
for
was
filing?
actually submitted, and it's old, it's from April. I can,
So it was submitted from,
April of last year.
Oh,
it was
last
submitted.
year?
Yeah, but I couldn't find it.
all right. If it hasn't been filed, we'll go ahead and file it.
Okay, great.
Very good.
Okay, I'm just gonna ask him, I'll take you through a timeline.
I don't think we're gonna have any
It'll-
trouble with level of conflict, cooperation, physical and mental health, all of that, but this
Sure.
factor about frequent associations
Sure.
beyond the limits of the court order, that may not be much we can do with that one per se, but we'll see.
Well, there's been a history of,
Okay, if you
by the-
feel that factor does lend itself, then
Yeah.
by all means.
so, all right. So you have a minor childhood issue with Kimberly Hurd, correct?
Yes.
Okay. And when did you guys currently aren't together right now, correct?
Correct.
Okay, when did you first separate?
Separated in October 2020.
Okay. And I'm gonna just take you through, and that way you can, it'll address all of the other sub-factors. So when you separated, was it you told her that the relationship was over?
Yes.
Okay, and then how did she respond?
She came, I was at my now fiance's work at the time. She showed up with Aslan, our daughter. Started making a scene and yelling, and then continued to walk out the door with our daughter and saying she didn't want to live anymore, and started walking towards the street, towards Boulder Highway, holding our child in her hand.
Okay, and what did you do in response to that?
I called 911 and grabbed her.
Okay, and did the police officers come out?
Yes.
And what happened after that?
After the police came out, they put her on a legal 2000, the paramedics were called, she was transported to Henderson Hospital, and Carrie was actually just getting off of work, so Carrie came over, grabbed Aslan, so she didn't see none of that, and took her to the car,
Who's Carrie?
my fiance.
Okay. And did the police make a report of the incident?
Yes.
Okay. I'd like to show you, you have the same binder, if you'll look at Exhibit 6. You're in. Have you seen this document before?
Yes.
What is this?
Incident report from Henderson PD?
All right, and is this on the date that you and the defendant entered a relationship?
Yes.
Okay, what exact date was that?
They only have like a couple binders right now. Wait till we get to later.
I believe since the time was 12 o'clock in the morning on 10/29, it was rough 10/28, 10/29, right around midnight.
And there's a narrative, it's on date stamp 5/16. Is that a true and accurate description of what occurred that day?
Yes.
Your Honor, I would request to admit exhibit number 6.
It'll be admitted.
Okay, so did you remain separated from Ms. Hurd after that date?
No, we got back together and I tried to work things out with her.
Okay, and so was there a date that you finally separated from Ms. Hurd?
February 14th, 2021.
Were there any other police incidents after you and Kimberly separated?
Yes.
Okay, when was the next police incident?
I believe it was March.
Okay. What happened that day?
Me and my fiance were out of town. I got a call from my mother that Kimberly broke into the house through the doggy door and started packing up most of Aslan's belongings and rummaging through stuff in the garage. And at that time, I also received an email that there was money stolen, transferred out of my account and Zelle to her. So
Okay, and where does your mother reside?
my mother resides with me.
Okay. And I'd like to show you exhibit number 7, please. Have you seen this document before?
I know we have a lot to get through. I know. But so tonight, then it was already awkward in there because of a relationship issue, right? And the band's playing, and and then finally the band stops like a little before they were supposed to. Not enough to be bad, but a little before they were supposed to. And for me, when I close, I always have to wait for the band to tear down and get out. Like, I can't just close my section and leave. I always have to wait for the band. Hi, Terry. Well, today, band tore down, and then I know the band. I know all the band members. I'm friends with every band that comes in there. Because we're a team. We work together. And the guy's like, listen, I need a shot. I need a shot right now. I'm like, no problem. I'll get it for you. He goes, I have the police coming to my house right now because my soon-to-be ex-wife is in there taking all of my stuff right now. I need a shot. So I gave him a shot. He drank it, and then he went home to find the police to have the police there with his soon-to-be ex-wife. I don't even know what happened. Don't worry, I'll find out.
Yes.
What is it?
Incident report for the call that night.
Okay, who made a call that night?
I called, I was in Kingman, I called the cops.
Okay, and that's Henderson Police Department?
Yes, ma'am.
Okay, and have you seen this document before?
Yes,
Okay, is this exhibit a true and accurate depiction of what happened that day when she broke into your home?
yes.
Okay. I move to admit exhibit number 7.
Admit.
All right, so let me just ask you, after you and Kimberly separated on February 14th, 2021, what was your visitation schedule with your daughter?
I didn't have them. She was all the time.
Did you ask to see her?
I asked to see her, I asked to FaceTime, and nothing.
How were you making your requests?
There was text messages and talking parents, and I believe a few emails.
Was Kimberly also using Talking Parent?
Yes, she's requested that I signed up for it because it was, the courts could see it.
Okay, I'd like to direct you to exhibit.
Kimberly suggested Talking Parents to begin with. Kimberly was the one who suggested it. So all this problem we're going to go through later of her not getting on Talking Parent, she's the one that suggested it.
13. Have you seen this document before?
Yes.
What is this?
This is all the messages in Talking Parents,
Okay, and messages between whom?
me and Kimberly.
I'd like to draw your attention to bait stamp 568. It's about 3 pages in. Are you there?
Yes, ma'am.
Okay. Now, it says your name on here. Are those messages that you actually submitted to Kimberly?
Yes,
And then it says Kimberly Hurd. Are those messages that she responded?
yes,
Okay. And on February 23rd, 2021, it says, wondering when you're going to allow me to have Aslan, and if she's still allowed to go to Latham this weekend. Did I read that correctly?
yes,
Is this one of many messages that you were asking for your daughter?
yes.
Okay. So from February 14th until when did she withhold your child from you?
April, the middle of April, I believe is the timeline.
April 2021?
Yes, ma'am.
Okay. And you also said that you were trying to FaceTime with her as well.
Yes.
And what were some of the reasons, if you could explain to the court, that she would give you for not allowing you either to see her or to FaceTime with her?
She would just say that she didn't want my fiance around, which she wasn't, and she kept calling me abusive and hostile, and I'm a bad person and a bad father.
Okay. And, Your Honor, I would ask that Exhibit 13 be admitted into evidence.
It'll be a minute.
Now, after March 22nd, 2021, were the police involved in your exchanges with Kimberly at all?
Yes.
Okay. Do you remember when the next time the police were involved? If you don't, I can. Okay. If I showed you a document, would that help refresh your recollection?
Yes, ma'am.
Okay, if you could look at Exhibit 8, please. Anything for today? This one's actually- Okay. Does that refresh your recollection?
Me too, Monica. Me too.
Okay, so can you tell the court what happened on October 22nd, 2021?
We went to the fall festival at her school. Kimberly asked me if she could take Aslan.
Just specify, go ahead.
She asked me if she could take Aslan instead of meeting up to do the exchange because we both were going. I agreed. We got there, and Aslan was enjoying the festivities, and we went into the library to look at the book fair. Aslan didn't want to be in there anymore, so Aslan grabbed my hand and we walked out. She came out, Kimberly came out, caused a scene in front of everybody, started yelling at me. Then she proceeded to take Aslan to the restroom, and after about 15 minutes, I went to go look for him, and the stroller and Aslan and her were gone.
And do you now know where she went with Aslan?
She went to her house, to the place she resided at the time.
So what did you do in response to Kimberly leaving with your daughter?
I called the police, they came to the school, told them the situation, and they asked me if I would want to be escorted over to the house to pick up Aslan, and I said yes.
So what happened when you arrived at her home?
We got to the house, the officers went up to the door while I stayed by the car, and she refused to hand over Aslan because they said it was a civil matter.
So whose day was it to have visitation with Aslan?
It was mine.
And did you end up getting her that night?
No, ma'am.
Now, I'd like you to look back at Exhibit 8. Have you seen this document before?
Yes,
What is this?
a police report.
Okay, and the police report, who contacted the police that day, did you say?
I did.
All right. And does this police report, is it a true and accurate depiction of what occurred that day?
Yes.
Your Honor, I ask for Exhibit
It'll be
8
in
to
there.
be there. Thank you. Okay.
There we go. Donald, there we sell it. It wasn't the court reporter, it's the judge. The judge is banging away on his keyboard.
Now, have there been any instances, other instances where you've had to contact the police due to Ms. Hurd's actions?
Yes.
Okay, can you tell me about another incident?
When she put trackers on her purse,
Okay, so tell the court about,
I believe in September of 2021, my fiance Carrie was going through packing up Aslan's diaper bag, and she noticed a sewn-in pocket that had a voice recorder into it. She let me know about it, so I went out to our vehicles to check for trackers, and there was a tracker under each one of our vehicles.
I would like for you to turn to Exhibit 14. All right, and what is this that I'm showing you?
That's a picture of the tracker attached to the heat shield behind the muffler on Carrie's BMW.
Who took these pictures?
I did.
And do these pictures accurately reflect what you saw when you found the tracker on both of your vehicles?
Yes, ma'am.
I move for 14 to be admitted.
Will be admitted.
Thank you. And if you would turn to Exhibit 15. Have you seen, there's 3 pages, have you seen these pages before?
Yes.
What are these?
That's the first page is the diaper bag, and the second and third is the voice recorder that was found in the diaper bag.
And the voice recorder, was it turned on or turned off?
It was on.
It was on. And who took these pictures?
My fiance.
And do they accurately depict what you saw that
Yes.
day? Okay. I move for Exhibit 15.
Yeah, because she doesn't work, so how could she afford them? I don't know. I just don't know. I just don't know the amount of energy it would take to just do all this. I was married for 19 years. I bet I still know. I mean, I had full access to his emails, to his bank accounts, to everything. I bet I still do. I bet he has to change his passwords and I can log in right now to whatever I wanted to. But why? Why would you even bother? It's not even close to worth it. It just takes you. It takes up your mental. Doesn't mean anything to him.
Be admitted?
Will be admitted.
Now, did you file a report with the police regarding the tracking under the vehicle and the recorder and the
Yes.
diaper bag? You did. And what is the status of that case?
Right now, it's an open case pending a warrant, pending judge's signature.
And I'd like to turn your attention to Exhibit 17. Have you seen this document before?
Yes.
What is this?
It's off of Court View. It's the docket for Henderson District Court, I believe.
And who's the defendant?
Kimberly Hurd.
And what is this docket related to?
This is related to the tracking devices and the recording device.
I move for the admission of Exhibit 17.
Will be admitted.
And you mentioned in your testimony earlier that Kimberly had removed funds from your bank account.
Yes.
Okay. Was she an authorized user on your account?
Not after we separated.
And does she have your permission to remove funds from your account?
No.
And approximately how much did she remove?
About $4,000.
And then were any of those amounts given back to you?
Chase refunded $2,000 that she Zelled to herself, and Chase also stopped payment on the two $725 payments to her credit cards.
So about how much did she keep of your money?
$500.
I'd like for you to look at Exhibit 57, it's in the other binder. What is this document?
Bank statement,
Whose bank statement?
mine,
Do you recognize it?
yes.
Is it true and accurate depiction of your transactions? in the
Yes.
account? Okay. I'd like to show you Exhibit MO000230, which is the second page. And you just testified about Ms. Hurd taking money from your account. Are there any entries on this statement that depict the money that she removed from the account?
It shows, on this page, it shows the reimbursement back to myself on April 1st, and on the previous page, it shows the $325 online transfer to another checking account that I had, and the $2,000 payment to her through Zelle.
Okay, so why don't you start with the most, like, at the top of the page and go down. What are the dates and the amounts that she removed?
On 3/19/2021, she transferred $325 to my other checking account.
Did she have access to your other checking account?
No.
No?
At one point she did, but
Okay.
not after we separated, after we broke up.
Okay, and the next one?
On
They didn't come.
3/22, she zelled herself $2,000.
And then review the transactions on the next page, please.
On April 1st is when Chase reversed his Zelle payment.
Okay. Your Honor, I move to admit Exhibit 57.
It'll be a minute.
So, did you file a police report?
Yes,
All right, and what was the result of your filing of a police report?
that is still an open case.
Okay, I'd like to turn your attention to Exhibit 16. Have you seen this document before?
Yes, ma'am.
And what is it?
The court docket, off court view.
Okay, which court is that?
District Court, Henderson?
And so if you can look at the top of. I think it's, yeah, I think it's Justice.
Oh, Justice Court, I'm sorry.
Okay, and who is the defendant in this case?
Kimberly Hurd.
And what is this case related to?
Theft of the money
The money from you?
from my bank, yes, ma'am.
Okay. And, Your Honor, I would move to admit Exhibit 16.
It'll be a minute.
Okay.
We absolutely have brown eggs in the United States.
Okay. Since you separated from Kimberly, has she ever shown up to your house uninvited?
Yes.
Okay, can you tell the court about one of those instances?
She came by the house when I was at work and parked right behind my fiance and was questioning where Aslan was and who was with Aslan.
And about when did this occur?
Around April of 22, I believe.
And was this a day that she was scheduled to have your daughter, or you were scheduled to have her?
No, it was a day I had.
Okay. And in response to her refusing to leave, what did you do?
Carrie called the police.
Okay. And was there an incident report?
Yes.
made? Okay. I'd like to turn your attention to Exhibit 10. No, I'm sorry, Exhibit 9. Have you seen this document before?
Yes.
What is it?
Incident report?
Okay, and does it accurately reflect the events from that day?
Yes.
Your Honor, I move to admit Exhibit 9.
Excellent, so a minute.
I'd like to turn your attention to Exhibit 10. Have you seen these photographs before?
Yes.
What are they?
Pictures of Kimberly sitting behind Carrie's car in front of my house.
Is this the same day that the incident report was made?
Yes.
And who took these pictures?
Carrie.
All right. And do they reflect the events that occurred that day when Kimberly was sitting in front of your home?
Yes.
All this proves is Carrie has it out for her. Why is Carrie taking pictures of her?
I move to admit Exhibit 10.
Yes.
Okay.
What about Cadbury, Donald?
I'd like to talk to you a little bit about when you and Kimberly discovered that she was pregnant with Aslan. Did you go to the doctor's appointments with her?
I went to some of them. I couldn't make all of them because at the time I had my own business.
And were there any health concerns concerning Kimberly?
There was one of the first doctor visits that she went to, the doctor, her blood results and test results came back with methamphetamine in her system.
And were there any health concerns concerning your daughter?
At the time, no.
Were there later issues that were brought to your attention concerning her health, your daughter's?
We found out when she was in the womb that she had trisomy 21, Down syndrome.
So, how old is she now?
6.
And how does having Down syndrome impact your daughter's well-being?
It doesn't, because she doesn't know she has it.
So what do you do, like, do you have other children?
Yes.
Well, you didn't just mean, he might have understood the how did it affect the little girl's happiness, because Benny said she's unaware, but I think you meant how does it affect the overall care of her and the challenges to him?
Yes.
Okay, why don't you elaborate on that a little bit?
Yes. You have other children, correct?
Yes.
Okay. What are the names and ages of your other children?
Dominic is my 23-year-old son, Cody is my 17-year-old son, and I have a soon-to-be 11-year-old stepson named Jeremy.
And how have you had to parent Aslan different than you've parented the other kids?
Not very different at all. I try to treat her like a typical child. Yes, I know there are some challenges. She's still working on potty training, but she's very self-sufficient. I honestly was scared and worried when I first found out I was gonna have a child with Down syndrome, but they're like normal kids. They act the same way, they do the same things as normal kids, and I don't parent them any different. She gets a little bit more leeway because of her disability, because she might not understand it fully, but, you know, and sometimes I have to scold her a little bit and tell her no, not to touch that, and she gets rewarded just like a regular kid does too for doing good things.
And I'm not trying to imply that you treat her differently, but all I'm trying to understand is, you mentioned that she's potty training still, so she's admittedly delayed in potty training, correct?
Correct, yes.
Are there any other delays that you've noticed in her life?
She's speech delayed, but she has been working phenomenal with her speech therapist. Her speech therapist has even acknowledged that she is doing amazing and progressing. She actually got 100% on one of her tests Monday at therapy.
Okay. And what's the current custody schedule that you have right now?
Currently, right now, Kimberly sees Aslan Wednesdays from 6 to 8 and Sundays from 4 to 6, supervised at Family First.
Okay. So, and how long have you had the schedule where you have all at the other time with Aslan?
I believe since February.
Since January.
January.
Okay. So since January, have you seen any growth in Aslan since you've had the majority of the time?
Yes, she's talking more. She
Unfortunately, she didn't show up today. She's a no-show.
has gotten better with the potty training. Her verbal skills are the biggest thing. Now that she's wearing glasses, she can actually see stuff better and understand things better. And when she's very well mannered, and when she asks for something, she asks for it.
When was
I have glasses and I can't see nothing. Never.
Using 3 to 4 word sentences is what they want right now. She's doing 3 to 4, 4 to 5 word sentences.
Oh, that's great. When was she first prescribed glasses?
In February.
In February of 2022?
Oh, yes, ma'am.
Okay. And
Exactly,
how often
yes.
is she supposed to wear her glasses?
All day long, every day.
Have you expressed to Family First that Aslan needs to wear her glasses?
I did express to family.
That's where we should be in court. That's criminal. That's criminal what you just typed right there. They should not be allowed to do that.
When she first got him, to please have her mother, had Kimberly make her wear her glasses. Any child that first wears glasses doesn't want to wear them all the time, but she wears them all the time with no problems, even without a strap.
So, to your knowledge, has Kimberly been assisting Aslan with wearing her glasses
No,
during
she is not.
visitation?
No, she isn't.
And how do you know that?
For the last couple months, I believe, Aslan's been coming out of Family First with her glasses in her hand, or the supervisor has been bringing her out with her glasses in the hand. And I asked if Aslan has been wearing the glasses, and she said no. She takes them. Her mother takes them off immediately when she walks in the door.
Does she explain why her mother takes them off?
She said that her own doctor said what I said was false and that her prescription was wrong.
To your knowledge, when's the last time Kimberly's taken Aslan to an eye doctor?
2019.
I'd like to show you Exhibit 33, please. Have you seen this document before?
Yes.
And what is it?
The reports from Family First Services?
And have you had a chance to read through it?
Yes.
Okay. Do you believe that it accurately depicts what you know about the visitation occurring at Family First?
Yes.
Your Honor, I'd ask for Exhibit 33 to be admitted.
Wait a minute.
Okay. You mentioned a little bit ago that Kimberly tested positive for meth when she was pregnant.
Yes.
To your knowledge, has she tested positive for meth any other time during these proceedings?
Yes.
And when about was that?
November of 2021.
Okay. I'm going to show you, you'll review Exhibit 24, please. Have you seen this document before?
Yes.
What is it?
Toxicology report from, excuse me, ATI.
And who submitted for the test?
I did.
No, not paid for it.
Oh, who submitted the courts?
No. The name of the person who took the test?
Oh, who submitted the test? Okay, Kimberly Hurd.
Okay. And so you paid for the test?
Yes.
Okay. And is this the test that you were referencing, that she tested positive for methamphetamine?
Yes.
And what else did she test positive for?
Amphetamines and barbiturates.
And was that in urine, hair, or both?
Both.
Okay. Your Honor, I move for the admission of Exhibit 24.
Be admitted.
And to your knowledge, did we make any other requests for Ms. Hurd to submit to drug tests?
Yes.
Okay. And do you recall what the judge ordered as far as how to let Ms. Hurd know that she needed to submit for a drug test?
I had to advise you before 10 o'clock to have her tested by 5. After 10 o'clock, she could be tested at noon the next day.
Okay. So I would like to bring your attention to Exhibit number 25. Have you seen this document before?
Yes.
What is it?
A letter you sent Kimberly requesting a drug test.
And what date was it provided to Ms. Hurd?
March 7th,
And-
2022,
And when was it electronically served to her?
at 8:49 a.m. on the same day.
Okay. Your Honor, I move for the admission of Exhibit 25.
Be admitted.
And I'd like to look at Exhibit number 26. Have you seen this document before?
Yes.
What is it?
Me and my kids have been fighting because I want to get chickens. They said I can't have chickens. I don't know why they say I can't have chickens. But if I made them buy the eggs in this house at $6 a dozen, maybe they would let me buy a chicken. And the only reason why I buy a chicken is because Temu has these little chicken skirts. These tiny little skirts you put on your chickens. They look so cute. Anyway,
Toxicology report,
And what is the date of collection?
March 7th, 2022,
Right, and who was tested?
Kimberly Hurd.
Right, and what did she test positive for?
Butalbital and alcohol.
And then what was her alcohol results?
0.10
And was that in hair or urine?
urine.
Your Honor, I move for the admission of Exhibit 26.
Be admitted.
I also feel the chickens will annoy my neighbors, which is another pro.
I'd like to bring your attention to Exhibit 27. Have you seen this document before?
Yes.
What is it?
A letter from you to Kimberly requesting a drug test.
What is the date
April 15th,
and what time was it served?
8:34 a.m.
Move for the admission of 27. Exhibit 27.
One more time, Ms. Crum.
I move for the admission of exhibit 27.
Oh, I'm sorry, it's submitted, sorry.
Okay, thank you. If you'll now look at exhibit 28. What is this?
Toxicology report,
And what is the date that it was collected?
April 15th,
And who is the person that went for the collection?
Kimberly Hurd,
Okay. And in her urine, what did she test positive for, if anything?
butalbital, and alcohol.
I move for the admission of exhibit 28.
It's admitted, since there's no opposition to any of the exhibits being admitted, it seems pretty clear by court review that there's at least a foundation for admission plus quite a bit of relevancy in most of them. Do you want them just all admitted and block at this time, or would you
That would
like
be
to
great.
separately move for each one? They'll all be.
They'll all be admitted.
Okay,
Perfect, thank you.
you bet.
All right, so exhibit 29, what is that?
Drug test. Letter from you to Kimberly for requesting for a drug test,
And what's the date on that?
May 20th.
Okay, and then if you'll look at exhibit 30, what is that?
Toxicology results,
And what's the date that it was collected?
May 20th.
And that was from Ms. Hurd as well?
Yes.
Okay. And then if you'll look at exhibit 31, what is that?
A letter from you to Ms. Hurd for a drug test.
All right, and I'd like to point your attention to date stamp MO000899, which is the proof of service. Was Ms. Hurd served a copy of this letter?
Yes.
And what date and time did she open the letter?
August 4th at 2:47 p.m.
So is your understanding she's supposed to test on August 4th?
Yes, because the letter was sent at 9:51 a.m.
Okay. I would direct your attention to exhibit 32. You've seen this document before?
Yes.
Okay, what is it?
A letter from the toxicology department.
Stating what?
She didn't show up.
Okay, and so what are you asking the court to do with her failure to show for her drug test on August 4th?
Continue to let me have sole legal custody and physical
No.
custody.
No. The correct answer there was tase her. Tase her, tase her. A miniature cow, what about a miniature pig? One of those little teapot pigs.
Do you think that that's important?
She made all the other drug tests. Why didn't she make that one? And I believe for her actions and, again, her looks that she is back using.
Okay. After you received sole legal and sole physical custody, did you make any attempts to get Aslan's belongings from Kimberly Hurd?
Yes.
And were you successful?
No.
So did you go to her home?
I called Henderson PD to assist me over there.
And what happened?
Officer went up to the door, asked for Aslan's medication for her thyroid and her medical inserts for her shoes, and the officer was denied.
Was an incident report prepared relating
Yes.
to that? Okay. I'd like to show you exhibit 37. Have you seen this document before?
Yes.
What is it?
The incident report from the evening I tried to get Aslan's belongings.
Okay. And does this accurately depict?
Yes.
And prior to using Family First, was there another location where you were allowing Kimberly to see your daughter?
I would let her choose a random park located by the houses, by my house.
And was that the successful way to have visitation?
At the beginning, the first couple times, yes. Afterwards, no.
And why was that?
There was a few instances where she refused to hand over the child, and there was another, and the cops had to be called. And there was another incident where my fiance went to go pick up Aslan, and she refused to give her over to Aslan, and told her that she can just go. She's not her mom.
So, when you said there was an incident report, I'd like to show you Exhibit 38. If you could look at that document. Have you seen this before?
Yes.
Okay, what is it?
Incident report from the evening of February 10th.
No, I don't think it's February 10th.
Or, I'm sorry, February 9th. I'm looking at one of the process. February
Okay.
9th.
And what is this incident relating to?
I was watching Aslan play with Kimberly. She decided to walk off and walk over by the lake, with being out of my line of sight and not letting me know that. And I had to look for her. And when I found her, I questioned why she did that. And she said she can do what she wants. And I said, okay, well, if that's how it's going to be, then I will kick Aslan. We can go home right now. And she said, no, you're not. She turned and walked away. And I was afraid that she was going to take off with Aslan, so that's when I called the police.
Do you currently have health insurance for Aslan?
Currently, she's on Medicaid.
She's on Medicaid, okay. And is your desire that as long as she can stay on Medicaid, she will, but if not, then you'll secure health insurance?
I can get help. She can be put on my health insurance.
Okay. And the payment of the premium, how would you like the court to divide that?
Half.
Yeah, that each party pay half? Okay. Now, does your daughter receive SSI benefits?
Yes.
And who receives the benefits on behalf of your daughter?
Kimberly.
Is it true that she receives $841 a month?
Yes.
Right. Now, since you've had sole legal, sole physical custody from January 2022, have you received any of those benefits for your daughter?
No.
Even though the court has ordered her to turn them over, has she given you any money?
No.
Have you received any child support for your daughter?
No.
Okay. So from January 2022 to the present, are you requesting any back payment of child support?
Yes.
And what is Kimberly's educational background, if you know?
She has a bachelor's degree in psychology.
And what other jobs has she had that when you guys were together?
She was a model, brand ambassador, bartender.
Has she ever had a job in the legal field?
She was a paralegal before we started dating.
And what amount do you think she has the ability to earn?
Probably $25 to $30 an hour.
So are you asking the court to impute income to her?
Yes.
How many drug tests did you pay for with ATI?
4.
And do you remember how much each one cost?
$126.
And what are you asking relating to your payment of the drug tests?
Reimbursement.
Now, early in the case, we had a meeting with Kimberly and put together a holiday plan that was filed. Are you asking the court to utilize the holiday plan that we submitted to the court?
If she can prove to the court that she's suitable to have non-supervised visitations down the road.
Okay, but for now, what do you want the court to do regarding her seeing Aslan on holidays?
Do it at Family First Services, supervised.
And in the proposed holiday schedule, there is a requirement that if you travel, you provide the address and telephone number and ticket information. Do you understand that?
Yes.
Okay, and are there any modifications that you're requesting regarding the itinerary requirement?
I request that she doesn't have to have addresses or phone numbers of places that I may be staying due to the fact that I don't, with the stalking and the trackers and her ability to research things, I don't need her to know where family and friends live.
So what's the last trip you took with Aslan?
We went to Minnesota,
And who did you go and visit?
Carrie's mother.
Did you feel comfortable giving her Carrie's mother's address?
No,
And why not?
because I think she could figure out a way to say Aslan got hurt while she was on her property and try to sue her and go after her mother's house.
And just to be clear, I think, will you look at Exhibit 11?
Yes,
Is this the cost to add Aslan would be, as of February 10th, $176.21 a month?
yes,
And then to add her to the dental plan, it would be $82.60 and vision $14.97, correct?
yes.
Okay. And I just want to be clear, if you'll look at Exhibit 20. You seen this document before? I'm sorry, I'm not sure if you're-
Michael, I like how you
Yes.
think.
okay. And what is this?
It's a letter from Social Security stating that Aslan gets $841 in SSI.
And since January, who has made most of the medical appointments for Aslan?
Myself,
And have any appointments been canceled or rescheduled since January to present?
there was one, her orthopedic had to be rescheduled, excuse me, because I called to verify the appointment and was informed that Ms. Hurd called the doctor's office and canceled that appointment and made an appointment with another doctor, the previous doctor she was going to, who was no longer at that office. So I rescheduled that appointment for the same time.
Did she ever tell you why or what was not sufficient about the doctor, or if she went to take a different tact, or she,
No, so the
or was it just purely a control thing, basically?
I believe it was a control thing, Your
Okay.
Honor.
Okay. So there was no pretense even that, well, this doctor can pursue this while this one can't, or anything like that, or I don't agree with this one's diagnosis, nothing like that, just,
No, this was just
Okay.
a routine checkup on her
Okay.
orthopedic inserts.
very good, thank you.
And, let's see,
We're all waiting. We're all
I
waiting.
feel that the dates, scheduling time for Kimberly to see the minor child at Family First have been going.
I personally would like,
She
I
didn't
don't
show
like
up.
Sundays, only because it hinders doing things with Aslan for a weekend, especially out of town.
To your knowledge, is Kimberly employed?
No,
Has she been employed during the inception of this case?
no.
So what are you asking the court to do regarding the scheduling visitations?
To move the times from Wednesday and Sunday to Tuesdays and Thursdays from 6 to 8 p.m.
And where would you like it to occur?
at Family First Services.
You know, I'm wondering if, usually if someone doesn't appear, they're not gonna cooperate with the structure of some court-ordered supervised visit, so it may be best to just indicate that until we return to court, Dad will control or decide Mom's contact as long as he does so responsibly and fairly, and that if she wishes to
Oh, I love this judge. That's perfect. That's perfect. Tammy, how you been? We haven't seen you in a while.
Establish a specific supervised visitation schedule, she can come to court to do so. Otherwise, it sets him up to have to spend money and time to drive over and wait somewhere with his daughter at a place where someone's probably not going to show. Because people who intentionally blow off court hearings where they're on supervised visits don't cooperate with any future such visits. She didn't cooperate with the last couple. So unless you prefer it, it doesn't
No,
matter.
that
One way or the other, whichever
Yes.
way you prefer.
That's what we would prefer.
Okay.
Last thing that I wanted to ask you about is regarding attorney's fees. What are you asking the court to do?
To reimburse me?
And so you're asking to be able to submit a memo, fees and costs.
Yes.
And do you believe that she has the ability to pay attorney's fees?
Yes.
And how so?
She has the ability to work. And she's also right now has my daughter's SSI money. But my daughter shouldn't have to pay for her attorney's fees or for her spending.
How much is that derivative? How much does that benefit the Social Security disability?
It's $841 a month.
I peeked.
Okay.
And, Your Honor, I don't have any further questions.
Very good. I don't think I do either. It seems to have been all covered very thoroughly. So, based on that, did you wish to, let's walk through it.
Sure.
And then you can incorporate it into the order. Court's going to grant the father sole legal and sole physical custody and indicate that till further order he will
I'm
he
so
will
sorry.
cooperate
I'm so
with
sorry,
mom's
Tammy.
visitations on a supervised basis, and that if she's agreed with that, she can re-petition the court. Unless you feel it's beneficial to set up a new supervised schedule with a provision that if she doesn't appear for the first, if she's a no-call, no-show to the first two, that it can default to the order of he will decide her contact in a reasonable manner till further order, whichever. Either way, which would you prefer? Which is in the best interest of the child, you think?
So, yes, he'll do the default. He will make sure he gives her enough notice so that
Okay.
she can coordinate through, it's her responsibility to coordinate with family first.
Okay. A, we would agree wishes of child is of sufficient age and capacity to form an intelligent preference is not an operating factor in this case, correct?
Correct.
B, any nomination of a guardian
No.
for the child not a factor. C, which parent encourages frequent associations beyond a technical court order? So which parent is more likely to allow the child the frequent associations and a continuing relationship between the non-custodial parent? You had asked him a few questions, it seemed, based directly on that. So what findings, and he provided some anecdotal information. So what specific finding or findings factually would you
I would
like
ask the
to be
court
into
to
them?
find that she withheld the child from February 14th, 2021 until May 2021. And thereafter, there were other times that she withheld as well. I can give more testimony, but we've provided exhibits showing that when she is asked to change the schedule, based on her schedule, he's always been flexible and allowing to do makeup visitations. Those exhibits are related to, let's see, Exhibit 50 through Exhibit 56.
Okay. Now, in this case, usually we just have the minutes reflect the orders and refers to the video record for the findings, etc. But
Where do I begin? I'm not going to get this right. I'm going to get it way wrong. So, mother and father were married. They had a daughter. She has Down syndrome. I believe she's 5 or 6 right now. Mother's crazy. Mother puts tracking devices on the father. Mother keeps bringing him to court over and over again. Mother's crazy. Mother's been through 2 lawyers so far, and now she's pro se because she does not have a lawyer. At one point in her life, she was a paralegal, so she has a little bit of court knowledge. Um, she she does meth, so she talks a lot. Yeah, and recording. Mom is really nuts. Dad isn't a saint, but um, mom is really nuts. So mom put this motion in order, and then for today's conference hearing, and then mom never showed up. So they are making a final judgment right now on the placement of the child, and they're going to place the child with the father. And mother can have visitations when the father says she can. That's what he's saying. However, mom's going to come back into the picture. Not today. This is a long series. So mom's coming back into the picture full force pro se, and we'll see more of this glorious judge.
To help with the preparation and maybe reduce or eliminate the possibility that you have to wait through a video. We'll ask the clerk on this, and but on any of these, if you need us to repeat anything or slow down, just let us know. She's really quick and good, but we just want to make sure she gets everything. They'd indicated withholding from February 14th to February 21st of last year.
Through May.
Oh, through May, February
2021.
through May,
Yes.
February 2021 through May 2021, mom had withheld the children, and plus the courts is indicating based on that, plus the testimony of dad as bolstered by exhibits 50 through 56, established that factor C is in dad's favor, statutory factors to which parent is more likely to allow frequent associations between the child and the other parent. Very good, okay. Just ask us anything that needs clarification, because it's not easy necessarily. D, the level of conflict between the parents. I think we have quite a lot of ammunition on that. Go ahead, please.
The level of conflict is high. We've submitted exhibits 6, 7, 8, 9, 10, 13, 14, 15, 16, 17, even canceling the medical appointment, that's exhibit 19, and just showing that she is not cooperating. And also, exhibit 33, which is the family first, where because dad is saying have her wear glasses, mom is taking them off when the child walks in.
Okay, the court finds that D, statute factor D, level of conflict between the parents, that the mother by far is far more responsible for the conflict than the father. She's primarily, if pretty much solely responsible for the conflict, and that's bolstered and supported largely by exhibits 6 through 10, as well as exhibits 13 through 17. Likewise, exhibit 19 showed canceling the child's necessary medical appointments purely as a power play. Exhibit 33 is to the family first report, and the rest of the testimony of the father and the complete pleadings and papers on record in this matter
So I would add
support that
37
that
and
factor
38.
D is heavily in the father's favor. I'm sorry?
37 and 38.
And,
two more
and
police
exhibits
reports.
37 and 38, the police reports, okay? All right. E, ability, again, as you mentioned cooperation, so some of this bleeds over. E, and you can reiterate, the ability of the parents to cooperate to meet the needs of the child. I assume on E, for starters, you want to incorporate by reference all of the relevant findings on C and D as well.
Yes.
Plus some additional, in addition for E, incorporating, because a lot of C and particularly D with conflict also speaks to cooperation or lack thereof, so I assume you want to incorporate that all by reference. And in addition to that, you would like to bolster that by his current testimony and the complete record in this matter, plus any specific exhibits or other material that would I think we have enough on this, but if you feel that it's also bolstered by additional exhibits beyond the ones we mentioned, that's great as well, however you want to handle it.
Yes, so in addition, let's see, the testimony regarding the withholding, because that's a failure to cooperate, and then also, Your Honor, and on exhibit 23, that's just information regarding she unilaterally enrolled the minor child into activities, and even though the court told her not to, she did it again. So there's information that we provided as well. I'm just trying to find which letter.
Okay, so for starters, Ani, if you're looking to see if there's anything else, we incorporate by reference all of the findings and exhibits referred to in factors C and D, plus supplemented by exhibit 23, the unilateral withholding in violation of the clear-cut order, supplemented by Dad's testimony relative to the withholding, and if you have anything else on this factor, that's fine.
Okay.
I think you have more than enough, but it never hurts to make the record as strong as possible if there's anything else you can think of.
Yeah, the only other thing I would add, Your Honor, is we referenced earlier the correspondence, which was 48 through 56. You'll see in those correspondences where each time she would ask for a modification, we would grant her that, but if he asked for a modification, she would say no of the visitation schedule, so I would add that as well.
Okay, 48, everything that was just mentioned, plus exhibits 48 to 56, which bolster that when mom seeks an accommodation, dad reasonably and readily agrees, but that mom, on the other hand, is quite obstructionist. Very good. There's an interesting one which I think has very significant relevance in this case. F, the mental and physical health of the parents.
Yes, Your Honor.
Okay.
We have all of the police reports, which I believe there's some mental illness going on with those. So that's 6 through 10 with the photographs of her sitting in front of the house. And then
I'm pretty sure Maiko is in every single live, all the time, all the lives. Todas.
14 is the tracking devices and the reporting device, that's 14 and 15. She has 2 criminal cases that are open, which are 16 and 17. And then we have the ATI reports, which are exhibits 24 through, with my letters requesting them, all the way through exhibit 32.
And you said 14 is the tracking devices, 16, 17 open criminal cases, and 6 to 10 is photographs of her, sitting on the curb or what?
They're the police incident
Oh,
reports
the police
and
incident.
the pictures.
Okay.
And then there are.
And the photographs show her on these premises sitting on the curb or?
Yes.
Okay.
She refused to leave. And then also, even in their talking parents correspondence, which is exhibit 13, it shows her instability. And frankly, even in looking back at her filings, she admitted that she's has some depression issues, which I was going to talk to her about.
Okay, for starters, and then we'll, on F, which incorporates by reference everything already discussed on C, D, E, and F, and that C, D, E, and F, all of them, including F now, is a factor heavily weighed to the father. On his side of the ledger, he's very well-adjusted young man who's doing a sterling job with raising them.
No, he's not, though. No, he's not. We all know he's not. And it scares me that he has custody because he's not.
And raising a blended family, including this child. But defendant, on the other hand, is a young woman with some very serious, unfortunate challenges, which she's not addressing, and in fact, which she seems to be indulging. Factors, in addition to incorporating by reference everything discussed in factors C through E, 6 through 10 are police incident reports, photographs that reflect the defendant being uncooperative and on the premises. Exhibit 14 indicating tracking device, 16 and 17 reflecting open serious criminal cases of defendant. Exhibits 24 through 32 were, 24 through 32 were.
Those are the requests for drug tests and the.
Oh, yes,
drug
requests
tests.
for drug testing and various documents surrounding the drug usage. 13 was talking parents exhibit, plus the overall testimony and the totality of the case and defendant's own admissions through the paperwork of serious depression issues, which are very challenging and sometimes almost debilitating in day-to-day challenges or parenting. And the court also has to make a comment on this issue. It might have been that the legislative intent was to establish findings based on actual medical testimony or records, but as a practical matter, there's often a lack of that in most cases, and it's impossible often to obtain those records if they're in the possession of an uncooperating party, or more to the point, if the party has not acknowledged the issues to the point of seeking the necessary treatment. That's also a problem. So the court does find that without necessarily being in a position to diagnose the defendant, that there are some social and behavioral and adjustment issues and some drug dependency issues and some depressive issues which are impeding seriously her ability to effectively parent, particularly when considered in conjunction with the totality of the records and all the findings on C, D, and E. That said, is there anything else necessary on F?
On F, I didn't know if you mentioned 15, which was the recording device.
Oh, yes, we have the tracking device, which is 14.
Yeah,
Tracking
and
device,
I
okay.
didn't know if you mentioned 33, which
I might have
is,
mentioned 14, I don't think I mentioned 33.
okay,
So let's go ahead and
yeah, so.
reiterate what 33 is.
33 are the supervised visitation notes.
Oh, that's very important, yes.
Yeah.
Okay, the supervised visitation is number 33, excellent.
Judge, the incident reports, which
you
were
go too
37 and 38.
I'm sorry?
not sure if you mentioned 37 and 38.
Those are police incident reports?
Yes,
Okay, let's
those are
get that in
additional
there.
ones.
Okay. Very good.
Okay.
Okay. G, physical and developmental and emotional needs of the child. Now, obviously here, there is a documented special needs issue. So,
Yes.
in addition to incorporating all the relevant findings, and when we say incorporate by reference all the relevant findings from C to F, that doesn't mean the minutes or the order have to restate all those. It just means it refers back to them. So we don't have to go through a lot of retyping of everything, just of course incorporate by reference. So physical, developmental, and emotional needs.
Yeah.
Aslan, we already know her situation to a large extent, so go ahead and amplify for the record how you would like her
Sure.
condition phrased for the purposes of the order.
She has Down syndrome. She's in therapy and speech therapy, is currently working on, they expect her to have, you said 2 to 3 word sentences, but she's having like 3 to 5.
4 word sentences.
Okay.
She's doing 4 to 5.
She has medication that she takes, inserts in her shoes. We've attached as Exhibit 5 her IEP, which she will be 35% in the, am I right about 35%?
34% in a normal classroom and the rest in a self-contained classroom, which will benefit her in the long run.
3466. She's actually better off developmentally than a lot of children with Down syndrome, so that's something to be grateful about.
Yeah. So.
If she's a third of the time in a normal classroom, a lot of them aren't.
Yeah, she was mostly in there just getting bored in the afternoons.
Yeah, so she's probably advanced in some senses. Okay, so for G, in addition to incorporating all the relevant findings of C through F, Ashlyn is diagnosed with Down's syndrome. We've heard testimony about the medication, the treatment, the IEP. She's in regular class about a third, two-thirds in the self-contained classes. It's clear that mom does not only support, when you have children with special needs like this, you have to have both parents pulling the ox in the same direction. You can't have this type of friction. And mom obviously is undermining the situation, not the least of which was specifically canceling a critical appointment
And Your Honor.
for nothing except, and appointments for nothing but control freak reasons, I suppose.
And sorry, I didn't mean to interrupt
No, no problem.
you.
So, no, I want you to add, those are the
Yeah.
basics. I want you to add whatever else.
Just
We
to-
have medical record exhibits,
Right.
which for the most part will really help bolster this. Which specific ones do you believe should be referenced?
In the talking parents, there's testimony and the incident reports that we named earlier where he went to the house to get her medical inserts and medication and clothing and she refused to give it.
Okay, so we'll mention that the talking parents report, the incident report where he went to get not just her clothing, but necessary medication and other treatment items, and mom
Yeah.
rejected that, denied that, which
Exactly.
causes a serious situation.
Yeah, there's communication on Exhibit 13, Bait Stamp MO 000653, where he says you continue to refuse her medication. and also
Case
you refuse
13
her
about
inserts.
medication refusal
Yeah.
based
And then-
on a special needs medicated
Brand new board.
Down
Yeah.
syndrome child, and that's a serious finding. And so G is a factor which likewise weighs heavily in favor of the father, who's extremely well equipped and committed to this process, while mom appears anything.
Your Honor?
But yes,
Sir, also on August 2nd, I had my mother, since we were out of town, I had my mother go pick up Allison's prescription at CVS, and they told my mom that someone already picked her prescription up.
okay.
She was still receiving text messages from CVS that prescriptions were ready.
Now, since he's obviously under oath, do you feel that additional incident should be included in the findings on August 2nd?
Me too. Some of the things he says drives me insane. Like, no, Judge, that's wrong. But some of the other things are so great. Like, I wish all the other judges would say stuff like that. Ugh.
She undermined the situation by picking up the
You know what Beck said? You know what Beck said when she sent me this clip for this trial that we're watching right now? She said, I sent this to frustrate you. And she's right. She is right.
prescriptions. Also,
I am not bored. No.
The $841, is she receiving that, correct?
She is.
The money needs to be going to the primary parent to help offset some of the large expenses of this undertaking. And the fact that the mother is using all of that for her personal use, while the father would be using most, probably all of it, and then some, for necessary treatment for his daughter's Down syndrome is kind of appalling. So that can also, if you want to mention her keeping the 841, which needs by law to be going to him, to factually for him to apply those costs to offset these extreme expenses, well, she is retaining all the money and there's no proof she's spending any of it on daughter. In fact, she's not, because she's not even pursuing the supervised visit. If you want to include that,
Yep.
and you
He does that all the time. He does.
also want to include what he mentioned about the August 2nd incident where the prescription had been picked up apparently by her, right? And she can't administer it since she has supervised visits, so Was this,
Oh my God, Bill is here, everybody. Hi, Bill. How are ya?
merely, this was not just a controlling action, but probably a malicious action?
Oh, yeah.
This was, the court finds this is a malicious action that damages, their daughter, since dad needs the medication for Ashlyn very desperately. And mom has no earthly use of the medication because the child is not in her care even on a supervised basis, so she could not be administering the medication. So it's just another power or control play, but in this time, one that's quite malicious and could only be damaging to a child. And I don't think that's overstating the severity of it, is it? If you feel it is, we can arrange the findings however you wish based on the evidence, or do you want it, how would you want to phrase what you think's appropriate?
No, I think that's appropriate between that and then even having the child remove her glasses when an eye doctor, she hadn't taken the child to the doctor since 2019 and he's taken the child this year. And the doctor has advised him she needs to wear them all the time, you know?
So mom is undermining the necessity of Ashlyn's utilizing eyeglasses at all times, and mom has interfered with that as well. How, if there's anything more in that fact or exhibits, did you want to list any further exhibits, or does that about cover everything?
I think that
sufficient?
covers it.
Okay. H, this is always sort of a vague factor, the nature of the relationship of the child with each parent. I'll say at this point, C through G is in all relevant factors are incorporated by reference, and the child looks at dad as the caregiver, as dad is the caregiver, and his wife as his wife or fiance as the mother figure, obviously.
Yes.
So whether you want to make a statement as to what she views mom as or the nature of that relationship, or whether it's fractured, or whether it's more an absentee situation or distant situation. You
Well-
mentioned dad is the caregiver, total caregiver, and dad, she views dad as such and is totally bonded with dad in a very loving, close relationship. Now, the question is, how do you want to frame the mom's relationship? The mom's not acting
Fozzie, be nice to Bill. What if he leaves and doesn't come back here anymore? Think about it. Tell him he looks pretty today.
responsibly relative to the child and medical and other needs or the court orders, but it does the daughter still love her, or just view her more absentee, or what? I mean,
I think her daughter still loves her.
Okay.
Of course,
She
the
shows
daughter
up
loves her. Bill, you look very pretty today.
with crafts, it looks like in the family first, but however, I think she knows that it's an unreliable situation. I mean, for the past 2 years.
Fozzie's nice
her
to
mom
everybody.
was holding her when she was about to run into the street and saying she doesn't wanna live anymore, and her mom's been on meth. So even when she withheld the minor child from February through May of 2021, she was on meth and she wasn't working, so she most likely was using the SSI funds to support her illegal activity, and she was withholding the child from dad. So that means she was doing meth while she had custody of a child that has Down syndrome.
I've sent lots of pics to people I left.
that probably more than covers everything on this factor. And you can include some of that. Do you need any of that reclarified, or that, I think, and I, the ability of the child to maintain a relationship with any sibling. So the court will incorporate by reference everything from C to H, and indicate that maintaining the child with the father maintains the bond she's created with half siblings and step siblings.
Yeah.
And maybe there's not much else that needs to be said on that
Right.
factor. J, any history of parental abuse or neglect of the child or a sibling of the child. There's clear, the court incorporates by reference everything already elucidated that's relevant from C to I, and indicates that the totality of everything we've already determined clearly establishes parental abuse and neglect, and probably any exhibits or testimony or evidence we refer to would just be a repetition of items already in the record of the other factors, and we're incorporating all that by reference. But that said, if you feel there's any additional criminal reports or anything else we haven't mentioned which further amplifies this issue, that's great as well, whichever.
Not any additional, just the same ones.
Okay.
She has the 2 open criminal cases and all the incident reports that we referenced. Her meth use again, like what I just said, that while she had custody of the child, her failure to appear for her last drug test, which I believe the court would deem to be a
Okay,
failure.
so C through J, all those are heavily in favor of the father, and I think J is more than fleshed out.
C through J. CJ. CJ, we miss you. I'm sorry, Ardo.
We incorporate all the aforementioned exhibits and material of the other factors. K, whether either parent or any other person seeking physical custody is engaged in an act of domestic violence against a child, a parent of the child or any other person residing with the child. Now, the court will find that we incorporate again everything that's relevant from C to J, including all of the exhibits, criminal reports, etc. And I think the totality of that would justify the court in making a finding by clear and convincing evidence that the mother's committed acts of domestic violence. But if you want to be a little more specific as to against that or against who or whatever, and if you want to repeat any of the exhibit numbers, I think you covered it all very
Ad nauseum. Don't let me pet that dog ever. Never. Because I will take that dog. You will never see that dog again. If that dog was anywhere near me, oh. I just felt it was like a soulmate the first time I saw that dog.
very thoroughly. But if there's anything, if you want us to conclude who domestic violence was committed against him and or the child or whoever, and if you have any exhibits or testimony or anything you want to refer to, and anytime we refer to incorporating by reference
Sure.
all the exhibits of the and findings of the previous factors, we're also incorporating all of the file papers and legal papers filed to date.
Bren, is that your dog? Is that really your dog? Is it? Because it's so far away I can't even come steal it some night. Where? Is it a little girl or a little boy? I don't want to call it anymore. I need to know what my doggy's gender is. Oh, so it's a little boy. Oh, Brad, will you marry me? I'll give you a green card, please.
Yeah.
And everything that's occurred, all the hearings. So that being said, is there anything else you would?
No, the only other thing, I would just, the Exhibit 6, which is the
Okay.
incident report from October 29th.
Well, add the incident report. We'll reiterate that letters number 6. And did you want to make a finding that she's committed domestic violence against your client, the child, both, or?
Just the child, there's
Okay.
no
Just the
claims.
child.
Yeah,
Okay.
no claims against him.
So factors A and B are kind of irrelevant. Factors C through K are heavily in favor of the father for the reasons mentioned. We have one left. L, which is not particularly germane for the following. It says, and this one will incorporate on reference all the findings of the earlier factors, all the exhibits in the total case file. Whether either parent or any other parent seeking physical custody has committed any act of abduction against a child or any other child. Generally, this is viewed as abduction as established by criminal law proceedings. If it's more, if it's more like lack of cooperation and withholding, it's pretty thoroughly covered in the other factors. So to the extent that this is asking, to the extent that this factor is meant to inquire about obstruction or withholding, the totality of the record's heavily in favor of the father and heavily against the mother. To the extent that the legislative intent, which I think it was to, if I could make a finding that under criminal law an abduction has occurred, I'm not necessarily sure we need to go there, unless someone did file with the AG or something about anything. Okay.
Your Honor.
Did you wish to make any comments
About
on
the
that?
abduction? No, just withholding, I think he was,
Okay.
if he didn't have these rulings, he would be seeking some compensatory time. Regarding subsection K, he just wants me to be clear that he's never seen her physically harm the child, but he's
Yeah, I was wondering about that.
placed her
That's
in
why I
a-
asked, because I don't think
Yeah.
it was an alleged physical. So how would
Yeah.
you like to?
All-
Physical, domestic violence, also defined as extreme neglect if you have a Down syndrome child. So it depends how expansive. It depends on whether this was meant by the legislature more of a criminal law definition where there has to be a physical battery, or more to the point, more subtle forms of domestic violence, which, like where domestic violence becomes kind of close to neglect as well, you know, like,
And that's the only thing that he's saying is it's been more neglectful, that if she's doing math or, you know, doing God knows what, that, you know, she's been withholding the child isn't safe in her care.
yeah, it's always an interesting factor, because you want to some people say domestic violence is very broad, such as, I don't want you visiting your relatives or friends.
Right.
But not from a criminal perspective, that wouldn't get you arrested, that's not a battery, but for the definitions used for civil or custodial matters, something like extreme control like that would be considered a form of
Right.
domestic aggression. So we always have to look at these definitions through the prism of, do we really mean a strict criminal or rigid definition, or are we painting with broader civil strokes? And I guess that's always an open question. But at this point, I think we're well served, based on all of that, sole legal custody, number one, sole legal custody, sole physical custody to the father in this custodial order. Number two, dad to determine mom's contact until future order. And I think the reason that's best, you can add in there that the court, based on her apparently abandoning her interest in participating in this litigation, plus blowing off, but not availing herself of the prior last couple or last one or two supervised contacts, as well as not appearing for the last narcotics test, would tend to indicate that she's not going to know of or cooperate with any supervised visitation order. So why inconvenience and create problems for him where he has to work something around his work schedule and drive down here and get his daughter ready for, and disappoint her greatly for contact, which isn't going to occur. So maybe it's best if he, I don't know, if mom calls, if she puts her on, Aislinn on the phone or some video conferencing or whatever. Has she been calling at least on the phone or for video conferencing or anything?
No, sir, she's
No.
only tried to FaceTime her daughter like 4 times since January.
That's extremely unfortunate. At this point in time, as far as support, mom was to pay on a temporary basis the supervised visitation fees in lieu of support. However, we don't have supervised visits at this time. I don't know to what extent she's employed or even employable. I don't know. What's your request on, I don't know what information we know or don't know.
$2,000 a month.
Testified that she has.
I know we do
Yeah.
have that as testimony.
She has a bachelor's degree, she's been a bartender, she's been a paralegal, which is why it's so
Right, but is she
voluminous.
working now, do we know?
No, every time we've come to court, you've directed her to find employment and she hasn't. And so, but her FDF, when you look at it, it's so upside down, I don't know how she's surviving, if it's accurate.
Is she living by herself, do we know?
She hasn't listed anybody else living with her.
What was the last position she had?
She hasn't worked since 2014, I think.
Ooh, wow, wow.
She was periodically,
She hasn't worked since 2014. Is that a joke? Donald, there is zero chance of me ever getting a wood chipper. Ever. Never. Look at the prices. I could buy 2 dozen eggs with that. No wood chipper for me.
jobs here and there, but never.
Plus, I'm violently offended by the warning signs that they put on wood chippers, because I think we should just let life choose and take away those warning signs.
Her full-time job.
But she was a paralegal for John Spilatro before, which is why she hasn't had to pay for any of her filings, but is why she probably has the ability to draft her own. So she is employable. I mean, even with that law clerk website, she could be doing this for other people. I mean, look, we asked for 24 an hour. I think she could make 15 doing fast food. And as many documents as she's filed, like if she spent that energy working, she could be employable.
The court, all of those findings and representations can be incorporated along with the court findings that based on that she could reasonably earn $24 an hour. Now, to better protect the record, even though there's a finding that she could work for 24 an hour, that would protect the record greatly and that there would be no
She has a bachelor's degree in psychology. I'm not lying. That's what they said.
excuse to not generate at least the pretty de minimis amount of 15 per hour. So if it's set upon 15 an hour, we'd be looking at that 415, 420 a month. So you're asking support to be set at 420 based on $15 an hour,
Okay.
with the specific finding that it would appear based on everything you just indicated that can be incorporated in the order, and in this very open economy where employers are begging for employees, that the court finds by clear and convincing evidence plus the judicial taking judicial recognition of the state of the economy, $24 is a very supportable figure, but that to protect the record fully from any meaningful, rational, logical attack or challenge, we're setting her at basically a minimum wage or close to it, which is really lowballing her earning capacity if we consider that past history, the educational degrees, et cetera. So there'll be no excuse not to at least tender 420. Effective what date?
Your Honor, we would ask, she didn't pay.
I went on a date once, a blind date with a doctor in psychology. And I don't even know what happened. I don't even know how all this happened. All I know is we went to dinner. We had a lovely dinner. He picked me up, drove me to the restaurant, and then he was going to drive me home. Okay? So we go to dinner. We're on our way home, and we're talking. And he asked permission to pull into this Home Depot parking lot. There's a lot of people there. So that we could talk a little bit more before he drives me home. He said he wasn't done talking yet. That man sat in that car and talked at me. I think we pulled into the parking lot around 9 p.m. That man sat there and talked at me till 5:30 a.m. It didn't stop. And he finally takes me home and he's like, wow, that was great. And I was like, okay, bye. I never ever contacted him ever again. He was a doctor in psychology.
For all her visits. My client paid for some of her when visits were changed. I would ask that the court go back. I mean, we originally asked for support, but at least until January, when he had sole legal, sole physical custody, that she should have child support
Of this year?
arrears.
Okay. The court finds that to be a very reasonable request in the premises. So for arrears of 1/1/22 through 8/31/22 are $420 a month for 8 months. It's $3,360. So effective September 1st, the support will be $420 plus 80 on arrears of $3,360 for a total of $600. The support can be enforced by garnishment or any lawful means, but since even if a garnishment, first of all, we have to find out where she's working, and if she is, then, and a garnishment attempt through the DA family support could take months. So at any rate, he can pursue that through the DA family support if he learns she's working somewhere. Plus, she would be required to immediately provide this order to payroll or human resources to commence a wage withholding. But if she doesn't, he can report to the DA. But to eliminate any excuse that people often make, I didn't pay because I thought because a wage withholding was ordered. Until such time, if and when a wage withholding becomes effective, she has to start making direct payment. And since there's so many arrears and so many months not paid, there's no valid excuses of I was afraid of a double dipping. I was afraid that I wind up paying twice in a month because I pay directly, and then 2 days later, the wage withholding takes effect. It's not a viable argument in this case. The 180 arrears is a little high, but the court's setting it a little higher than usual, in part out of basic fairness or equity, because the support is probably set on the far low end of her capacity and probably below her earning capacity. Okay, so Father, to the extent that taxes is a concern, of course, father claims for tax purposes. And you indicated this is a Medicaid
It is.
case, so the 30/30 rule would apply there. Now, aside from all of that, is there anything else beyond the attorney fees issue?
Your Honor, is there a date until the wage withholding is in place? Is there a date that child support's due?
Child support, the arrears are from 1/1/22 through 8/31/22 at 4/20, through $3,360. So effective, the next payment, which is due September 1st, will be the 4/20 principal amount, plus 180 on those arrears of $3,360 from 1/1/22 through 8/31/22. So that starting September 1st and then the first of each month thereafter,
Okay,
it's 600, which is 420, and then 180 on
okay.
arrears. I mean, obviously, you've prepared him for the realism of how effective or how long it may take till things are straightened out to the point where she's acting responsibly, paying the support, all that. It may be it may or may not be effective, just like the attorney fees. I'm bringing over with optimism that there be any meaningful compliance on that, if any, but you are entitled. And it can be true in some cases, there's a reversal of fortunes and people pull their lives together and a year or two down the road are far more responsible than they were, in which case collecting the support and attorney fees becomes much more viable. So these orders are really in place, not so much for the here and now, but in the hope springs eternal, if her situation really improves and she gets going on hops on board in the future. That said, if you're suggesting an attorney fees amount, the court can entertain it at this time, providing that with the order that you submit simultaneous with that, either a separate matrix with cover explanatory material, or you simply incorporate into the order the findings relative to.
I don't even think that's a real question. There's no real. They're not equal. M&Ms and Skittles are not equal. Skittles are okay. They're good to eat every once in a while, but M&Ms, come on, they're delicious.
Brunzel, that would probably be sufficient and would eliminate the need for a collateral material or matrix or memorandum. So if you indicate an amount now and the court conditionally grants it, in the event that you can simply provide the Brunzel material, which would be your material about your
We'll submit.
your
Oh my God, I'm down to 3,000 subscribers. Oh, Fozzie left.
You don't have to. You can either submit it separately or you can keep it clean. If you want to keep it just in the context of the divorce, here's your experience, training, success in the law and all that, plus the fact.
Why are you talking to my cat? Did you guys know I named my cat Judge Fleischer yesterday? That's his name now. Don't talk to my cat. The cat's mean.
Of what work was necessary and that it was what orders were granted, how favorable the outcome, what hourly fee, all that. If it's satisfactory, which it usually is, the court usually will sign and say that's sufficient. There have been a few cases where it said, well, let me ask for some supplemental memorandum of cost, but so either if you feel comfortable just asking for an amount, the court will grant it with the understanding that if for some reason the court thinks it's too high based on what you provide as Brunzel material,
That's how it
the court
begins.
will either just change the amount in the order or direct you to modify that slightly. It would seem unlikely that would occur, but that's could happen in a case. With that said, do you know what you're requesting so far?
Your Honor, I would rather submit it with
Okay.
everything that we did, and
Okay.
that way I can serve her, and we have it completely submitted.
Okay, if you want to handle that separately then.
Yeah. And then,
You can file a memorandum of fees and costs, leave a blank in the custody order for,
We need a tiny 1 minute and 45 second break from this court case, guys. We just do. Hold on. I want to give you that link so that you could all watch it, please. Because then he'll have 50 views. Except you're not all going to watch it. 3 of you, 4 of you might. But if you all watch it, he'll have like 50 views. It's 1 minute and 45 seconds. It won't hurt. It won't hurt. It won't hurt you one bit to just click like and watch it real quick. Am I going to get demonetized because of that music? Probably. But that's okay. That's okay. Okay, back to work, guys. Back to work.
for the attorney fees, the court will fill it in. As long as it's, now, the custody order should refer back to the Brunzell factors in the filed memorandum of such and such date. So you would either need to reiterate and retype all that, which probably isn't necessary, or at least refer back to the memorandum and the filing date. Because sometimes a court of review might say, well, okay, you gave this person the money, maybe it was appropriate,
Right.
but you didn't tell us. And then the attorneys or the judge says, what do you mean we didn't tell him? We had this separate memorandum of fees and costs. But if that's either not filed and or it's not reiterated in the custody order, or at the very least referred back to, that's what causes problems. But if you were to indicate, here's the amount, that you're requesting a certain amount, that, let's say the court agrees with it, fills in the blank on the electronic order, let's say someone requests 10, 20, 40 grand, whatever it is, and that's listed by the court in that, and if as long as it says, comma, as established in the memorandum of fees and costs filed on September 15, 2022, or whatever, which establishes the Brunzell factors in significant detail relative to the case and the charges, that would probably be more than sufficient.
Okay.
As long as it indicates again, so to that end, you would want to file the fees and not just provide the fees and costs to
Right.
chambers as like an ex parte submission, but formally file it,
Yes.
send it to the other side,
Yes.
give them a chance to respond. That way you can indicate in the order, it was filed on such date, served filed on September 15th, whatever,
Right.
electronically sent to defendant that same date, no response has been noted or a response of some sort was filed on September 22nd, which the court presumably considered. And based on that, we're requesting this amount, and then in the order itself, you would leave that blank that plaintiff was awarded attorney fees and blank, comma, based on the memorandum of fees and costs and all the detail as filed on September 15, 2022, or something like that.
Sure.
Okay, very
Your
good.
Honor, there's only one other issue, which is the order that the SSI payments will go to plaintiff. You've ordered that 2 other times, but I'm asking for the payments from January through, by the time we get this order signed, we'll have received the September payment. And so-
Yeah, oh, yes, thank you. The order is that immediately, I don't think you're, that immediately as to the very next payment that is to be processed, whether that's the September 1st payment or the October 1st payment, that upon presentation of this order to Social Security Disability, that the payments are immediately routed from the father to the mother. Now, you kind of want to, I don't know when the payment's going to be received in September, but the sooner this custody order is, and there's a lot of material in this custody order, I understand that, and you've got a gazillion other cases, but the sooner it's prepared, the better, because
Right.
if it can't be prepared before September's payment, that's just the way it is. But if it can be prepared before October's payment, that's great. So if they, because the point being, you'll also have a clause that she has to reimburse him
Right.
for the months from since he received custody, which would be, what, January or what?
January
Yeah.
through the August.
So, but just as a practical matter, trying to get blood from a turnip, it's the problem. So with the understanding that the September payment is ordered to be made directly to him. Now, if you want to prepare a separate, like, since the custody order, yeah, it could take some time, obviously.
Right.
Yes, Patrick. Dad won. Dad won. And then they go back. And that's where, I think that's where we're going to start. I'll find out before we end today if we're going to start the big case or if we still have more of these little videos to do.
You got a gazillion other cases, it could take weeks. But maybe a short one paragraph order just indicating, directed to Social Security and indicating this is Social Security disability relative to this matter, that the September payment or whatever the next payment is, from here on after will be given to the father, which indicates that the payments from January 1st through August 31st, 8 months of payment, presumably $6,648 that she would owe by reimbursement, because it's 8/31, right?
I have one correction. I looked at her FDF that was filed May 21st, 21. For January, it was $794. And then the letter that we put on the record, it increased February to $841.
841 or 831? 841?
It's $841, yeah.
Pardon?
$841.
841, okay.
From February through August.
Okay. So from February through the end of August, we have $5,887 and then $794 in January. You can delineate that out in the order. So that leaves us with.
That's why everything that's about to happen is going to happen. Because she flips. This right here must break her mentally.
6681, and you can delineate that in the order that shows the Social Security reimbursement from 1/1.
No, the child has Down syndrome. This could be lifelong.
22 through 8/31/22, and it's calculated at 794 for January, and then 841 for each of the ensuing months. Let's just double check that again.
And it's Exhibit 20, that was the.
Okay, and we
increase?
can reference that.
Okay.
So 5887 for that 7 months plus 794. Did I say 6681 earlier?
You
Because
did.
that's what it, okay, $6,681 is owed by way of reimbursement. I mean, it's one of those things, good luck collecting, but yeah, again,
Right.
looking at things through the prism of today, I wouldn't be betting much on collecting support attorney fees, social security reimbursement, but I get the idea philosophically behind a case like this. Is you hope and pray things turn around, and not only, mainly, of course, by far, improvement for their daughter's life, but then if things really improve, he can start receiving back, even if it's slowly but surely, some of the money he's owed.
Yeah.
That's probably not realistically gonna happen as long as there's a narcotics addiction, but the idea is you hope someone overcomes that.
Your Honor, can I add that if there is a wage withholding, that the collection of the SSI money would be included? And maybe that the arrears payments would continue until both the child support
I
and
mean,
SSI are
you
paid?
could indicate in there that it'll be assertively track the issue, but that until the 841 of the SSI money is rerouted to him, as long as it's still collected by her, that the 841 would need to be taken, as well as the 600, the 420 and the 180 on arrears. The problem is she's just gonna quit, but that's just the practical concern. She's not gonna sit still for that kind of, that would probably hit the 50% threshold where they can't withhold more than that. She might quit at the 600 even, but we can't really worry too much about whether someone's gonna violate orders and quit employment. But you can if you think it's, in the off chance she gets a really high salaried position that she doesn't wanna lose, which doesn't necessarily seem realistic at this point, but who knows?
Right.
Who knows? Anything can happen, we hope it does. She's got a couple degrees and everything, I mean, some decent work history, so we hope she turns it around to some degree. All right, very good, it may take a while. What, is there anything else for today's purposes, or?
That's it, Your
All
Honor.
right, thanks so much, thank you very much, and best of luck. Thanks for looking, thank you so much.
Yo, perfect timing. My dog said I'm done. My dog wants me, and when my dog wants me, then I have to go because I love her so much. So I'm going to get my dog, who's just waiting for me so patiently. Hi, babes. All right, no OJ today because I have to work soon. Anyway, thank you so much for coming out. Let's just double check this real quick. So this was August of 22. We saw that. July 18th of 23, part 1. This is where she starts, I think. That's part 2. So that looks like that's where we're going tomorrow, but I just want to be sure. Yeah. And then January of 24. So the last video, see, was November of 24. Look at that. We don't get to see 4 videos. That's fine. It's fine. We don't have to see them. But that's where we're at. So when we start tomorrow, we're going into 23. We're going to start. Wasn't there a January of 23? We're going to start in July of 23 tomorrow. And that should take us to the end. I don't think we're going to rewatch part 9. Because if you need a refresher, you can always go back to the video that I already made. So we're going to skip part 9. Part 6, I mean. We're going to skip part 6. And then do the rest. So, aw, Drunken, thank you. Thank you so much. Let's see who you got. I know this case is, I didn't think I would like it half as much as I did. And you know what? She didn't even show up today. And not all of it was very exciting, but a lot of it was. I was still engrossed in it today, even with her not here. I'm looking, Charlotte. Come on, Charlotte. Come on, Sue. Charlotte and Sue. Nope. Nice try, though. That was a great effort. Thank you. All right, guys. I like it with her, though. This is a good case. I'm glad we're doing it. See you all very soon. Sooner than you think. And maybe tomorrow. Bye, guys.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Dream tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Her eyes hear a sky so blue. In her jokes there's a truth so true. With each stream she brings the light, turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no